Welcome to Bloomberg Law. I'm Pacchia. We're looking at the new patent law today. While the America Invents Act hasn't quite gotten the attention of, say, Dodd-Frank, it will mark a dramatic new way of doing things in the IP space, and it has garnered a sharply divided opinion on whether it will ultimately prove beneficial for our society. Joining me now is Dorothy Auth. She is a partner at Cadwalader, Wickersham Taft, and she specializes in intellectual property law. Welcome.
Hi.
Thanks so much for coming in.
Thank you for inviting me.
So this is a young law. 5 years from now, if we can kind of look out into the future, where is the American Invents Act going to be in the public's mind? Is it going to be living the high life in Awesome Town, or is it going to be slumming in Failuresburg?
Well, I think it's going to be a bit of a mixed bag. The American Invents Act really changes the law that we've been working under for the last 50, almost 60 years.
Mm-hmm. We were talking before, this is an entirely new system.
Entirely new. We changed from being a law system that rewards those who invent, individuals. Mm-hmm. If they're the first one to invent, they get the patent, to a system where whoever gets to the patent office first gets a patent. Mm-hmm. And it goes against the entrepreneurial spirit of our country. Mm-hmm. You know, we're the cowboys, we're the capitalists. Right. It undermines that a little bit.
Now, I imagine logistically it presents a huge challenge. We'll get into that in a moment about how the U.S. Patent Office now has a much broader task ahead of it. But what are some of the other effects that come out of changing from first to invent, or first to file to first to invent?
No, we'll
I
go
had
the other way.
Wrong. Sorry.
From a first to invent to a first to file. The biggest and most immediate ramification is that it no longer matters if you were actually the first person to make a widget. It only matters if you got your patent application to the patent office first. And so that advantage goes to the person who understands the patent system the best. Mm-hmm. And that generally is whoever knows the rules. And those are generally patent attorneys. So when you have an individual inventor who comes up with a brand new widget, he won't be aware that he has to run as quickly as he can to the patent office in order to protect his widget. And in the meantime, he may be telling people. And under the old law, he would have a year, even after he told somebody, to file his application and still be protected. Mm-hmm. That's gone now.
But this is going to harmonize our system with the way things work in other parts of the world, namely Europe. Are international jurisdictional issues going to, I would imagine they decrease, right? This makes everything seem to operate more simply.
Well, there are rules as it relates to how you get a patent that will become similar to the way it's done in Europe. However, the European system is based on an entirely different set of rules that don't really apply in the United States. And so for us to go to a first to file system doesn't have the same advantages that it does in other parts of the world.
Mm-hmm. Net, who wins, who loses under this law?
I think companies that are following the developments of this new law and are going to know the rules the best are going to benefit. Mm-hmm. The folks that are less savvy mm-hmm. and might stumble the first few times they try to protect their new invention are going to suffer.
It sounds like there's a divide between large corporations that know the way the world works and entrepreneurs. Is that a correct statement?
Probably.
We were talking before about two sectors in particular that are going to be affected by this new law. Tech and biotech in some capacity, and pharmaceutical companies. How does this change the way that they do business?
Well, it will affect them in that there's another part of the law that's going to allow companies, patent holders, to challenge other or anyone to challenge a patent as it comes out of as it becomes issued from the patent office. And those, there's going to be a first procedure that allows you to do it in 1 year, and then the second year, and then after that. And it becomes a sequential way to challenge patents. Mm-hmm. And that is going to affect different industries differently. So high-tech industry moves very quickly. Mm-hmm. Changes, the iPad you bought yesterday is already outdated.
Sure.
So technology moves very quickly. And so if you the companies that are going to be using these one-year provisions and the second-year provisions are going to be technology that changes quickly and needs to be protected in order to get their product out in the market and needs to be challenged quickly. So that kind of industry is going to be utilizing this new system a lot. Now, to contrast that to pharmaceuticals are heavily regulated. They go through the FDA. They have to have clinical trials that require years of patient testing. Those patents, they have to be filed before any of that testing occurs. So the challenges to patents in the pharmaceutical industry generally happen much later than 10 years after the filings. And so they're not going to utilize this new system to the extent that the high-tech industry is going to.
Just prior to this law getting signed, we here at Bloomberg Law noticed two trends coming into play. First off, we saw a quick spike in patent-related litigation, and then we also saw a flurry of M&A activity involving patent portfolios. How have these trends played out since the law came into effect and months after the bill was signed by President Obama? Are they continuing, or has there been a drop-off?
Well, I can tell you about the spike in litigations. There's another provision in the law that is directed to curbing litigation by certain types of companies that basically litigate patents for a business. And they do nothing but sue companies for patent infringement. They don't make anything, they don't sell anything, except for suing companies. And
patent trolls is what we call them.
Yes, exactly.
Right.
Patent trolls. And so they used to, they had come into the habit of suing lots of defendants in one lawsuit. It was very efficient. The problem was that the only thing that was in common with all these different defendants is the fact that they had infringed the patent. They made completely different widgets in completely different industries. The new law bans that. It says you can only sue a company or multiple defendants if they have the same set of facts and circumstances that tie them together. It cannot just be that they infringe a plaintiff's patent. And that was the spike that we saw just before. And that has changed. It has dropped off now. And I think that was a very good intended provision because I think it will help the system.
So fewer patent trolls. And on the M&A side, we saw a little bit of activity around the time that the bill was signed into law. Going forward, I almost wonder, has the new law had an effect, or will it have an effect in the future in the way patent portfolios are valued?
Well,
is a patent still worth what a patent was 2 years ago?
I think that M&As will slow down for a little while. And the
Really?
reason I say that is because I think that even patent attorneys right now are trying to figure out what this law is about and how the new law is going to affect validity of patents. And validity is really what valuation is all about. And so there's going to be some uncertainty as to how the new law will affect the validity of patents.
Interesting. And that should be something that completely shakes up the M&A space. We just don't know how it's going to unfold.
Exactly. And there's going to be some uncertainty as to whether or not you can even trust the diligence that's being done right now.
Final assessment for this law. Did Congress get this right? They were working on it for such a long period of time. This was a long, drawn-out process. It seems as if the federal government and the business community knew that they wanted to reform the way we handle patents in this country for years, almost decades. Final analysis, did they get it right?
The law is so big. It has so many provisions. It's hard to say they got it right, they got it wrong. Certain parts of it, maybe they could have done better. But
what's the one thing you would change if you could?
I think there probably still should have been some damages reform. And that was a major part of the legislation that was taken out because there was so much opposition coming from different industries that they completely took it out. But having said that, the other provisions like the NPE provision that blocks certain types of litigations will automatically help with patent reform because they were getting some of these huge damages awards. So it's a mixed bag, and it's a big we'll see.
All right. We'll have to leave it there for now. Dorothy, thanks so much for coming in.
Thank you.
That's Dorothy Auth. She's a partner at the law firm Cadwalader, Wickersham Taft. If you'd like to learn more about the cases and issues we just discussed, go check out our intellectual property law report. It's available on BloombergLaw.com and also the Bloomberg Terminal. I'm Pacchia. Thanks for watching.